The court instructs you that the mere fact that the plaintiff received a fatal injury while working for the defendant does not entitle the plaintiff to recover a verdict in this case. Full stop. The plaintiff is not entitled to recover a verdict unless she proves by a preponderance of the evidence, comma, and by that is meant a greater weight of the evidence, comma, the following propositions. First, the plaintiff must prove by a preponderance of the evidence that she was at the time and immediately before she received injury, comma, in the exercise of reasonable and ordinary care for her own safety, comma, and that she could not have prevented the injury to herself by the exercise of such reasonable and ordinary care, full stop. If she could have prevented said injury, comma, then she was bound to do so, semicolon, and if you find from the evidence that she failed to do so, comma, and such failure contributed in any way to the happenings of the injury, comma, the plaintiff is not entitled to recover in this suit, full stop. Second, the plaintiff must also prove by the greater weight of the evidence that the top of the machine in question was in a dangerous and unsafe condition as charged in some one count of the declaration, comma, and that the injury was caused by such dangerous and unsafe condition, comma, and was not caused by any want of ordinary care on the part of the plaintiff. Para. Third, the plaintiff must also prove by the greater weight of the evidence that Jones did not himself know of such unsafe and dangerous condition, comma, and that he could not have known of it by the exercise of reasonable care, full stop. If you find from the evidence in this case that the plaintiff has failed to prove by the greater weight of the evidence all or any of the foregoing propositions contained in this instruction, comma, which you have been instructed, she is required to prove by the preponderance of the evidence, comma, then you are instructed that she is not entitled to recover in this suit and your verdict must be for the defendant, full stop. Para. You are instructed that there is no duty upon an employer to warn and instruct an employee as to the dangers which are open, obvious and patent to persons of ordinary intelligence, comma, and one who attempts to do work which exposes him to obvious and known dangers, comma,